All right, guys, welcome to the first real lecture that involves something that has to do specifically with sport law. This week we're going to talk about tort law and product liability. I'm going to try to make this as quick as possible, guys, but understand I will post this recording, which will have me adding some things that aren't on the slides to it, and I will post the longer PowerPoint on EagleWeb also. Also, I'll post a separate video that talks about the assignments for this week, and I'll send those out in email. So, tort law and product liability. So, you have to understand that tort law is talking about more about lawsuits. This is not really a necessarily a criminal action. We're looking at things like negligence, maybe the intent or desire to injure somebody, or we're looking at deals that have to do with product liability, meaning product failure, warranty failure, that are all tied to sports. And as we go through this, I'll try to give you some examples of specific court cases that have to do with these that kind of add to it. So understand with tort laws, they're not determined by judges necessarily. They're usually by juries, and there has to be a burden of proof, meaning that there has to be evidence. The jury has to believe the evidence, and there has to be guilt without a reasonable doubt. Or there doesn't have to be guilt without a reasonable doubt. And what I mean by that is in tort, you could actually prove that somebody is only 50% liable for an injury caused to somebody. So there doesn't have to be a 100% everybody agrees on what's going on. Usually this involves negligence, guys. And negligence meaning not doing what I'm supposed to do or doing something that's not supposed to be done or against protocol often leads somebody to become injured. So, I mean, there's tons of ways, and you could think of these that as sport managers, as people who want to work in sport, that that we could cause injury. One example from a case is that a fourth grade teacher, they're having field day, and she makes a kid sit out on the bleachers. He's not doing what he's supposed to do. And four other bigger kids get up there with him on the bleachers. They end up breaking the bleachers, turning them over. The one kid gets injured. And they sue over negligence of the teacher. So, in order for negligence to be proved, you've got only a handful of requirements. You have to basically prove that there's a standard of care, meaning you have a duty to the person who got injured. They have to then prove that there was a failure to act, meaning there was a breach of that duty, meaning you either did something you were not supposed to do or you didn't do enough. You have to prove causation, and you have to show damages. You don't have to show that there's an intent to injure the person. Okay, that standard's already based on the fault. So how do we determine standard of care? So, what determines what the standard of care is, for instance, for a coach. So the first way can be on case precedents. And what that means is if there's already a case that's dealt with something similar to this that already kind of shows what's going to happen, meaning somebody's already made this mistake before and the court ruled this way. There could be maybe legislation. For instance, maybe there's a rule that says that, or a law that says all high schools should have an AED every so many rooms, and something happens and there's not an AED. It could be that rules and regulations of the sport, maybe that says that, for instance, a wrestling mat in college has to be 42 by 42, and somebody wrestles on a 40 by 40 and gets injured out of bounds. That's a way to possibly prove that. And there could be like rules and regulations from administrative agencies. Okay, it gives the example of the Consumer Product Safety Commission, meaning, for instance, that soccer goals are supposed to be anchored into the ground. So if they weren't anchored into the ground, that would be, a violation of a recommended practice. So when you're looking at determinants of standard of care, you're looking at a couple different things. It could be stuff that's made by professional associations, meaning that maybe a certain association of coaches say that something should be done a certain way. It could be maybe a community has done that, industry standards. It could be expert testimony, meaning that they could bring somebody in to testify that the way you did something is not the way it should be done based on their expert opinion. And that can be a way to prove it. As we said before, you have to be able to prove negligence. And once you prove what the standard of care is, then you got to prove that there's a breach of that and that you basically didn't act on that standard. And then you have to show causation. Meaning, is there some kind of connection between your act and the injury? Meaning, did what you do or not do actually cause the injury? And was there actually an injury? And it's not just always physical, guys. It can be mental or emotional. There's a term of gross negligence, which is the same thing. It's just a higher degree. It means that you willfully or recklessly did what you did. There's still no intent to cause injury, but the intent to cause the action that you did result in an injury. Okay. So for instance, there's a fight in practice, and a player strikes a player. There's not necessarily an intent to cause injury, but there was a willfulness on their part to cause that fight, which that would be constituted as gross negligence. Now, when you go into defense, meaning I have to show, I have to make them prove that I had negligence. Okay. And there's a couple of defense. I could say that maybe I only caused 50% of the fault. Maybe part of it was on them. Maybe by the way that they acted, the way they didn't do something. So there's a chance that maybe I'm not all at fault. Maybe there's another party at fault. Maybe it's an organization at fault. Possibly it's the person who got injured at fault. So there's a lot of moving parts that go into this. And one of the common defenses is assumption of risk. And so what this means is that, say somebody gets hurt. We'll give the example. Let's say somebody gets hurt playing football. Well, there's a couple of things that the defense could show if they were getting sued. They might say, hey, there's a risk that's inherent in the sport. Okay, so you play football, you know what kind of sport it is. You should know that there's a risk in there. Maybe there was a voluntary consent. Maybe they had to fill out a form like all the forms you have to fill out for every sport. You're kind of voluntarily saying that you know there's a risk. And then you might be able to show that the participant understood the risk, meaning that they knew what they were getting into. So basically, to summarize that, you're trying to show that basically that whoever got hurt, the defendant voluntarily knew and appreciated the risk involved in whatever it was they were doing. In our example, it was football. So a couple ways I can prove that assumption of risk is, there could be an agreement of some type. That's why it's always good to have those written agreements or all those release forms. Or it could be implied, meaning that just the actions that the person took show that they knew they were assuming a risk. They took part in the activity, so they knew what the risks were by taking part in the activity. Now, switching gears a little bit, some more intentional types of torts are things that have to do with assault on one's character or their body. So meaning things like battery, assault, defamation of character, false imprisonments, or intentional infliction of emotional distress. There's also invasion of right to privacy, trespass to land, trespass to personal property, disparagement of property. So when we're looking at battery, it's basically unwanted or unpermitted touching of a person. And you've got to show that there was intent to contact, that there was harmful or offensive touching, that they were not allowed to or unpermitted to, and that there were damages that came from that. And this can be proven in something as simple as a fight in basketball. There's a court case where a kid punched another kid in the nose, and basically he was charged with battery. So you have to show that there was intent, and that there was harmful, basically behavior, harmful touching, and that there was an apparent ability not to do that, and that there were damages that came from that. So with all these things, it's not just as simple as just doing it. You have to actually prove this case. For defamation, which is something you all need to understand, that's basically making a false statement. And it could be published by a third party, and it's what harms a reputation. And it can cause an injury. It's not a physical injury always, but it could be an emotional injury. It can be written defamation. It can be slander, which is oral defamation. And basically, this is important because people are real quick to spat off at the mouth and put stuff on social media. And you have to understand that if it damages somebody's character, you can be liable for it. So how do you defend? A word of defense is defamation. Obviously, you can look at truth. You can see, were they privileged to it? So if they're public figures, you have to show actual knowledge that it was false and reckless, as well as falsity and damages. For non-public figures, which in most states, it has to be shown as a falsity and that there's damages. So you have to basically be able to show that what they said about you or talked about you or wrote about you or spoke about you was false. We're not going to cover as much about false imprisonment. It has to be just basically holding somebody or keeping somebody somewhere that they don't want to be. Understand that, inflicting emotional distress is just as bad or worse than physical distress. Okay, so you have to understand that you've got to show, if you're proving emotional distress, you have to show that it was an intentional act, that it was outrageous conduct, that it caused emotional stress, and that there were damages, which are emotional, obviously. Understand that invasion of privacy, so using one's name or likeness, intrusion, false light, public disclosure of private facts, all those things go into tort law. Invasion of privacy has to do with basically using somebody's name or their likeness, often for commercial purposes, without their permission. So this kind of goes in a little bit to dealing with maybe the video game stuff with EA Sports. Defense, if you're going to defend this, you have to have a consent. And, you could prove maybe or try to prove First Amendment right if it's not for commercial purposes, meaning if you're not making money. Intrusion, trying to search somebody's personal belongings. Okay, this gets into something interesting when like searching bags of students. Okay, the defense is consent. False light. It's real similar to defamation. It's basically it's shedding the person's or showing the person in a false light. Meaning, so for instance, you have a photo of an athlete with a woman other than his spouse in the newspaper, with a caption implying that maybe they're cheating with each other. It's very difficult to prove this, and the defense obviously is the First Amendment if there's not a commercial use of it. And then obviously right to privacy is pretty common sense. Okay, it's not making public facts that are private that would cause embarrassment or legitimate concern to the public. Okay, and it's claims difficult to make. We're not going to talk a whole lot about trespass on land or trespass on property. Now, product liability, which is the other half of this, is talking about liability that's caused by a consumer product. Okay, and it could be a bunch of things going on here. It could be negligence, strict liability, also could be warranties. And so it's the same elements that have to be proved with negligence. You have to show standard of care. You have to show breach of the standard, causation, damages. So basically, product liability is based on strict liability. It's liability without fault. So all these have to be present in order to prove this. That there's a defect, that the business was selling such products that's reasonably dangerous, that the plaintiff was injured because of the product, that maybe the defective condition is proximate cause of injury and the product was not substantially modified since the time of sale. So there's a lot going on with this. So you're basically essentially showing that there was a defect, that the product was made dangerously, and that there was no attempt to try to warn or to try to fix the product. So the defense is that you're trying to prove that they contributed to their own negligence, that there's an assumption of risk and a foreseeable misuse. Now, as far as liabilities with warranties, this is having to deal with that there was a promise that the product was made a certain way. That there was a certain reasonable expectation of the product. And so you see, you see these all the time. And the issue with this is no matter how well a product is made, somebody can misuse that product. They can use it in a way that's not supposed to be made. So, guys, I know I went through that kind of fast. So what will happen is I'll post this recording, but I'll also post this whole PowerPoint slide so you can go back a little bit faster or a little bit slower and take notes and look at it. So look for this, and also look for a video about this week's assignments. Thanks a lot.